Good afternoon, it's Alex Woods here, financial mis-selling litigator. I haven't posted for a good month, I'm afraid to say. I've been inundated as a result of having set up a new law firm, my own law firm, Redwood Legal. So, grand apologies to those select few who have been following my video bulletins on the cartoonbankers.com website. And I hope you'll be pleased to learn that I'm back in business and now recommencing what I hope will be, at the very least, fortnightly, if not monthly videos. So I've got a rather interesting couple of cases to talk to you about, and this posting is aimed at those people who may be contemplating what is the right avenue of redress, the right road to take if they've classically got a payment protection insurance claim and they're not sure whether or not the bank has made them a sufficiently generous offer. This dovetails, if you like, with the issue of compound interest, and I've blogged and soapboxed and trumpeted before the recent really rather crucial landmark judgment called Sempra Metals, to give it its shorthand name, which was a Supreme Court judgment which has had seismic ramifications on the way in which the courts calculate statutory interest or interest on top of your award, on top of damages, to essentially compensate you for the loss of the use of that money over the period of time from which you've been deprived of it by your opponent, assuming you've won your case. So this video is going to help to really clarify the decision that you'll be faced with as a consumer, wondering what to do with perhaps an offer or perhaps an anticipation that you may be made a low offer by a bank, any bank against whom you brought a payment protection insurance claim. So the first thing to say is you've probably come to the end of the 8-week process, and as I say, you may have either got an offer or your claim has simply been rejected. Now, if it's not a complex claim, then you should refer it to the Financial Ombudsman Service and wait for them to process it. They're taking anywhere up to 18 months or more to assess claims. You may want a lawyer to look at it at that stage if you think that it might be a complicated claim. I've spoken before about what I consider to be complex claims, so you need to look at another area of the website in order to arrive at an answer to that question of what qualifies as a complex claim. So I'm assuming that, let's say, your credit card company or your bank have made you an offer of $5,000 and you're wondering whether it's enough. And I'm afraid that you really do have to be somewhat suspicious of the banks. They are big, morally neutral animals who aren't really all that interested in reputation. I mean, their reputation's been absolutely torn to shreds, and they're still managing to function quite successfully and pay everybody bonuses quite successfully. So I don't think you should concern yourself too much with or think too much that the banks are terribly worried about their reputation. It's more difficult to change your bank than it is to get divorced, quite frankly. So people just aren't doing it. So I don't think the banks are really, the big banks, are all that concerned about their reputation. So this means that they will be making as lower offers they think they can reasonably get away with. It's an expensive operation running complaints procedures, and it takes quite a lot of overhead to appoint a sufficiently experienced complaints handler to give your claim the full justice of time that it deserves. So the first thing to do is to be suspicious about the offer that you've been made. I'm afraid to say that's the facts of life. Now, I would then, consider, as I say, the FOS route. And I'm now assuming that you're sufficiently suspicious you want to do something about it. I would consider the FOS route. Now, the Financial Ombudsman Service are just beginning, and I say that because we have been battering away at them to try and get them to change the way they function. They're just beginning to look at compound interest payouts on top of paying protection insurance claims. Now, these compound interest type payouts could increase your value of your claim by as much as twofold. So you could go from a £5,000 to a £10,000 claim. Again, I won't go into detail here, but you can see on another website, on another posting on the website, what I'm talking about. The video is entitled "Compound Interest: The Eighth Wonder of the World." So that's a sub-issue where you may feel that the banks haven't sufficiently compensated you for the time lost use of your money, typically where you've had a credit card, high credit card borrowings or any other high borrowings alongside the fixed term loan, which you will, in a case of a fixed term loan, paying protection insurance in the sale. Now, so that's Financial Ombudsman Service is one route, and you know, I would consider going that route. However, I think if it is particularly complicated, or you've made what you feel is really a derisory offer, then the options are to instruct a lawyer, to instruct a claims management company, and to run the claim yourself. Now, if you I'm clutching these files here because I'm going to come on in just a couple of seconds to two cases that I'm running that will illustrate the perils and pitfalls, but also the substantial rewards and gains that can be made by going the legal route. Okay, so hang in there. But firstly, let's deal with the claims management company. Well, I'm concerned about most claims management companies because I don't think that they're doing much for the 25% that they take out of your compensation. I think, however, there are some reputable, possibly smaller claims management companies who will actually properly assess the offer that the bank has made, and if they've got a legal partner, instruct a lawyer to try and get more if they think if they think that's warranted. Now, the other route to go down is actually bringing your own claim. I've started to post videos on this website as to how you might go about doing that. Basically, if your claim is less than £10,000, you can bring it through the small claims court. That's just like an ordinary county court claim, and you bring that through the county court, and because it's under £10,000, it's brought under what's called the small claims track, and that means that even if you lose your claim, you won't have to pay the other side's legal bill. The idea of the small claims track is it's there to keep lawyers out, meant to keep it simple, keep it straightforward, and you just get together in chambers with a judge and your opponent, and you know that's the way the small claims track claim works. So if the value of your claim is, or that your estimated claim, because obviously let's say it's a £5,000 claim, you may think that you're entitled to 10. Then whatever you believe to be the value of your claim, then if it's under 10, then you can go the small claims track. Now, I'm supervising a claims management company, a small one I think is reputable, needless to say, in how to offer a support service to consumers who want to bring their own claim through the courts. Why I like this is because it does keep lawyers out, it keeps it simple. It's a route, it's not for the faint-hearted, insofar as you do need a little bit of mustard in order to bring your claim, in order to sue a bank. But there is now, and we are setting up this support service. There's support there for you at a reasonably low cost. Basically, they'll take a percentage of your winnings, approximately 30%. It could be more if you want them to cash flow the court fees and other disbursements. But they will help you and provide a support service so that you could run your own claim through the small claims court, which I think is quite an interesting option. You don't want to get litigious. You don't want to get involved in the courts unless you can help it in life. But I think the one area in which it actually is worthwhile, and I always say to people, at least, you know, do it once in your life, because you'll learn a bunch of things, and you will feel, you know, empowered, and you'll feel as though you're taking charge of your financial affairs. And I tell you, you know, it will set you up as someone to be taken seriously in any future transaction or any future dispute, or any, you know, any future business dealings that you have. So I think it's you know, I very rarely hear people who've had a disappointing result from the small claims track, providing you hold your nerve and you go all the way to the trial. The other side will usually capitulate because they'll know that they're in the wrong. So that is a feasible option. Now let's say that you haven't managed to find a reputable claims management company, or you think that it's a high value or complex claim. Therefore you don't want to either take it through the small claims court. You're worried about what the Financial Ombudsman Service will do, and that they'll take 2 years to give you a no. And while the Financial Ombudsman Service may be better at assessing whether the product has been missold, the problem there is that they're not so good at assessing the quantum of the claim. They just basically bounce the decision back to the banks and tell them to pay up. But the banks, but then the banks don't necessarily pay up the full quantum of the claim. So now we come on to the main meat of today's video bulletin, which is to talk about 2 cases that I'm running. So you get the chance to, you know, get a window into the runnings of a law firm who specialises in financial mis-selling litigation. You know, just what sort of results is Redwood Legal achieving. Now, I'm slightly constrained by client confidentiality and other issues such as that, but I can talk in pretty, you know, detailed terms, really, in many ways, about these 2 cases I've got, because they're a good sample, a good kind of cross-section, give you a good idea of the sorts of claims that I'm running and the sorts of results I'm achieving. So here's the first one. It's against a large, very well-known retail bank. It's a credit card claim. Client is an ordinary consumer like you, me, or, you know, the average John down the street or in the pub. He was missold payment protection insurance on a credit card nearly 15-20 years ago, quite a period of time. And he was made an offer by this large retail bank of £1,500. £1,500. And he was made that offer approximately 2 years ago. He smelt a rat. He didn't think that they'd properly calculated the compensation on such an old credit card, and he protested. It's interestingly also complicated by the fact that the card was, I think this is the case where the card was bought from another lender. You'll often find that a bank will only make an award going back for as long as they've got statements, and then when the debt was owned, or the credit card debt was owned by somebody else, a predecessor, they then don't really bother to investigate for how long the payment protection insurance was on the card of that predecessor and what the likely value of it was. There's so many ways of not paying you full compensation in these types of claims and finding excuses not to pay you in full. Anyway, so in this claim, he smelt a rat. We are now 2 years on. He instructed me last year. We issued proceedings in his local county court in East London. And I'm pleased to say, it was interesting, this big retail bank instructed quite a established and reputable city firm of solicitors to defend the claim. However, I'm pleased to confirm that barely a few weeks, it's been barely a few weeks in which we've had an offer from this law firm of £11,500. So the claim has gone from 1.5 2 years ago to £11,500 now, and I'm still fighting that, actually, because we think the client is entitled to more, but £11,500 is in the bag. So that's a good example of, you know, if you do go the legal route, you do flush out a bank who is being less than straight with you about the amount of compensation in your PPI claim. I often feel I'm such an old cynic about these issues, you know, I wasn't, but I mean, it's just so endemic, this mis-selling, and I'm afraid the way that they're handling it is even more, you know, what's the word, shameful, because particularly Lloyds and the scandal they had recently with a company that outsourced their complaints handling to. It's even more shameful than the way in which they're trying to clean up the mess, because they're not doing a proper job. A lot of them. Anyway, by contrast, here's another case, and this one is a case against MBNA Europe Bank Limited. It's a credit card claim again, and in this case the client was made an offer over 2 years ago of approximately £7,500, and over that 2 year period we've commenced proceedings against the bank. These claims taken a particularly long time because I was working for another law firm, and that unfortunately that law firm wasn't as well set up to run these claims and were slightly reluctant to issue proceedings on claims, so that slowed the whole thing down. Going forward, for any of those who are interested in instructing me in one of these claims, I don't think the time scale of over 2 years is going to be anywhere near 2 years for you to get your claim to the courts. Anyway, in that claim, £7,500 was the offer. We've rejected that offer. What I thought might originally have been a claim value of nearly £25,000 has actually come down to 13,500, 14,000. And it's quite an interesting case, because the problem is these credit card companies, MBNA in particular, stonewall, and if you reject their offer, in this case £7,500, they basically pull up the drawbridge, they hold up 2 fingers and say, fine, you know, sue and be damned, and we ain't going to cooperate, and we are going to fight tooth and nail, and we're going to ignore your correspondence, and we're not going to enter into negotiations, and we're going to force you to take your case all the way to court, to trial. Now that's what's happened in this case, and it's interesting by way of contrast to the previous one, where really shortly after issuing proceedings and instructing solicitors they capitulated. In this case they're fighting tooth and nail, probably for commercial reasons, to discourage people from bringing claims to the courts, and the consumer probably won't get that 13 or 14,000, you know, until the end of the year, the earliest, and that's going to have been 3 years. And in many ways, he might have been better off taking 7.5 grand back then, rather than 14 or 13 grand, you know, 3 years thereafter. And indeed, there's still a risk, because this case is by no means won. And although it's a reasonably strong claim, there are always risks in bringing litigation and bringing proceedings against anyone, not least a well-heeled financial institution like a very large credit company, Bank of America no less. So there we go. That's a quick canter around your various options, and I'll just conclude. You have, and this is directed, as I say, I have to stress this, against people who are dissatisfied with the amount of compensation that their banks are offering them, or their credit card company has offered them in a claim. Firstly, take a look at whether or not they've included compound interest. If you think that your costs of borrowing at the time that you're paying for the PPI was very high, and look at other videos on the website about that if you need to. Then secondly, have a look at any other complexion of the case that makes you think you may have been shortchanged, or the cases are much higher value. You want to sort of assess its complexity initially. Financial Ombudsman Service is one route. As I say, it's better for straightforward claims. It's fine in most simple cases. In most cases, where you are disagreeing with the bank's assessment as to whether or not it was missold. It's not so good if you think that there may be an issue around the quantum of the claim, the value of the claim. So let's go to the next option, which is a claims management company. As I say, fine, providing you can find one who's reputable and you think are affiliated to lawyers who are going to check the compensation that they win for you to make sure that you're being paid enough. And they're going to fight your corner if they think that the banks, have, for example, returned an assessment that the product has not been missold. But beware, many claims management companies are simple postal services who aren't earning their 25%. Another option, go to the small claims court if your value of your claim is less than £10,000 and you've got the mustard and you don't mind, you've got the nerve. I think it's a good option. I encourage people to do it. There is a support service that I am pioneering and rolling out to assist you if you do want to go to the small claims track route. Finally, obviously instruct a lawyer. And if you instruct a lawyer, then as I say, in many ways the rewards could be quite substantial, very substantial indeed. On the other hand, you could end up with nothing because of the risk of litigation, or in the case that I've just alluded to, you could end up not really earning much more than you would have done had you accepted the bank's original offer. So, and of course, you also need to find a lawyer who is going to fight your case vigorously, because the banks know all too well that there are many law firms who've tried to jump on this bandwagon but don't have the commitment, the passion and the energy to see clients' cases through to the bitter end. And you need that, otherwise the banks will give you the runaround. Okay, so that concludes this week's posting. Thank you for checking in. I'm now officially open for business. I'm now authorised as a law firm, Redwood Legal. So, as I've often said before, if you've got any comments or queries, either post them on the website or email me at info@redwoodlegal.co.uk. Thank you, that's all for today.